Right.
You all may be seated. All right. We are back today on the matter of Abigail Guider.
My apologies, Your Honor, I was finishing a statement with
Okay, I
Ms.
apologize. Go right
Cheatham.
ahead.
Sorry.
You need another minute?
No, I understand.
Okay, all right.
Okay. We are back today on the matter of Abigail Guider. I think as I announced previously, there are several different petitions that we are here on. We are here on petition number 223883, which is the mother's petition for contempt and for modification of the parenting schedule. Mother's petition for contempt and for modification of the parenting schedule against the father, Mr. Sinai Guider. That was filed in November of 2015. We also have petition AC 223885, which is mother's pro se petition for contempt and for failure to comply with an order for visitation and parentage case. That was also filed November the 16th of 2016. We also have petition number 223886, which is the mother's petition to change custody in a parentage case. That was filed on that same November the 16th of 2016. Then we also have petition number 222962, and that is the father's petition to modify custody. That was filed October the 14th of 2016. There's also, just for the parties, and I don't see it right in front of me, and we'll figure out how to deal with that. There's also a restraining order that was heard and decided in circuit court that was transferred for here for the purposes of any modification if need be, that we have here as well. I'm hoping that's all we got. We have with us
like
today. That's a lot. We have with us today Miss Charlene Mack, who is the guardian ad litem for the child. We have Miss Cynthia Cheatham, who is the attorney for the mother, Miss Lydia Hubbell, who is with us. We have Mr. Brad Frakes, who is the attorney for the father, Mr. Sinai Guider, who is also with us. And then we also have with us
My assistant,
wonderful
Brent, my assistant, Your Honor.
All right, and his last name is?
Cheatham.
Okay, all right. Welcome. All right, and then for, I think we had Ms. Cheatham was with us on Monday by telephone, has just filed a notice that she is going to be representing Ms. Hubbell. We had a brief conversation by phone on Monday as to the order of the cases. We will do the contempt cases first, since they are criminal contempts against Mr. Guider, and then we will do the modification petitions after that.
Your Honor, permission to speak?
Yes, ma'am.
If you could, Your Honor, we need some clarification since we now have two new attorneys on the case as to the witnesses that we've actually heard from and at this point in time, because we heard witnesses out of order.
And this is, and let me restate again, what I recall, we have not heard anything as to the substantive cases
Right.
of any of these four petitions. The only thing that we heard previously was a pretrial motion as to whether or not the child could testify. We heard several witnesses about that. Let me get my notes out. We heard several witnesses as to whether the child would be allowed to testify. We heard from Miss Carol Pickett, who is a second grade teacher. We also heard from Elizabeth Goetz, who was the assistant principal at Gower, the child's school. And we also heard from Tracy Rose, who was the Camelot visitation supervisor. And we heard from Terry Ashford with the school psychologist with Metro National Public Schools. We heard from, that's Ashford, Dr. Berryman, Dr. Janie Berryman, and I believe that's all that we heard from. And the issue, there were two separate things we were hearing on that, and those dates were May the 10th and May the 12th that we heard testimony. The issues that we were hearing testimony is first, of course, whether the child would be allowed to testify. After hearing testimony, I did determine that the child would not be able to testify during the proceedings, based on the witnesses that I heard. We were also dealing with an issue from a previous order as to whether Ms. Hubbell's visitation time should have been unsupervised or supervised. And there was a decision at that time that there was not to be, that the visits had to remain supervised at the time. And so the only thing that we have heard in regards to any of the petitions was whether these current pending petition was whether or not the child would be allowed to testify. The other issue that we heard as to the supervised visit was in regards to the case that had already been appealed to the circuit courts, and most of the orders, except for the orders as to the Facebook post, were upheld. And so the supervised visitation was the only other thing that we heard. So we have not heard anything as to any of these petitions as of yet. And so these petitions are being heard by new attorneys, except for the Garnet Lytton, fresh and anew from the beginning. Does that clear everything up to everybody?
Could I have one moment with, in fact, could I have like 5 minutes with my client?
You may. You may. I'll step out.
There's one thing that I think I just want to be very clear on. When the court said the appellate decision upheld all but the some of the Facebook posts, that was based on a finding that the restrictions on her parenting were to be very temporary, and that's not turned out to be the case. So we're going to want that to be taken into consideration. One of the things that we were trying to decide today is whether or not these the facts that are in the contempt petition and the custody petition are better supporting a modification in custody for failure to develop, support and encourage a relationship with the other parent, or whether they are in fact an actual criminal contempt. And that's going to depend primarily on Mr. Geiger's knowledge about where Ms. Hubbell was in her therapeutic visitation. To that end, Ms. Hubbell has had under subpoena, my understanding is even from the prior hearings, Judy Mullins, who was instructed that this was going to reconvene Monday, was not here and is not here today, and is absolutely critical to those therapeutic visitation facts. And so we're asking the court to issue a bench warrant to require her presence. She's under a continual obligation to be here and not show a subpoena.
I would, Ms. Judy, and let me go back a step too. As to the issue of the appellate court ruling and this court's ruling,
Right.
There was definitely an effort to make sure that Ms. Hubbell was moving towards unsupervised visitation.
Right.
The problem became when Ms. Hubbell, or the agencies that were providing this, and this was all part of the previous
Right.
testimony in that May 10th and May 12th hearings, but Ms. Hubbell's relationships with the couple of different agencies that were ordered to provide supervised visitation because of different reasons.
I understand that, Your Honor.
Said that they would not do supervised visits. And so there was a second review hearing that we had
And
later
wasn't there
that was,
a finding that part of those problems was the agency supervisor was getting on her phone and
No, ma'am.
discussing other cases?
not from this court.
Okay. Wasn't there
but-
testimony at least that was
I
happening?
believe there was
And
some
an
testimony
admission
as to
that was happening?
but that was not a part of this court's finding.
Okay.
The main reason this court found that she was not ready to go to unsupervised visit was because of the things that she was doing in her supervised visits. And so, go back to the,
I think if there is an issue as to whether or not the therapeutic visitation and supervision problems are going to be laid solely at Ms. Hubbell's feet, there again, we do need Ms. Mullins here. We need some of the people that, were involved in that.
and so let me go back to the Miss Mullins issue. I do not ever remember issuing a order to Miss Mullins that she was under a continuing subpoena. The information that we heard previously under the May hearing as to her supervised visits, we concluded that there was a review later after that to see who was going to be able to do the supervised visits because all of the agencies said they would not do that. And so I do not recall from the bench ever telling Ms. Mullins that she was under a continuous subpoena to be back here on Monday. This was a pretrial issue from that time, so I don't even remember if she was here in the courtroom at that time. And it was a pretrial issue. The trial actually, she was here on the May.
And she was under subpoena and under Rule 45 of the Rules of Civil Procedure. Those were continuing in nature. And my client is stating that on October 16th, the video, she was instructed that her presence would be needed here.
On October 16th, that was
She
Monday.
was told to be here October 16th.
To be
May.
here on October 16th back in May.
Who was she told to be here by?
The court, Your Honor.
The court.
I do apologize.
Okay.
That is, I think I'm probably the only person that
Remembers that
that
thing?
remembers that day.
Okay.
Your Honor, as you saw, the other DCS worker had come on.
Who was Miss Mullins? I apologize.
She was the therapeutics, she was a former DCS employee who is now working for Camelot.
Okay.
She's the Camelot supervised visitation worker.
Okay.
We've heard testimony in regards to all of that with Miss Judith Mullins from her supervisors, but never heard the
Ms.
testimony
Mullins.
from Miss Mullins.
Gotcha. So she was here that day. We just
She
didn't
was
hear
here
testimony.
in the court,
Under subpoena.
just as the other DCS worker, who was the actual case manager, was present as well to return back. And she appeared on the 16th and has appeared again on this morning.
The DCS case.
The DCS caseworker, so they both were here. I agree with Ms., and I think Mr. Goodyear, if he would recall as well, since we're the only three that were there, that was the case, that was a continuing subpoena, because the court sat them down to look at the dates that we would be continuing the trial and to make sure that they would be available, because I believe Ms. Mullins had some personal things that she had to get taken care of, so I don't know even if what her matters are at this point. But, Your Honor, as to the court, we also heard, we came in for a status review on this case in June of 2017, and I don't know if Ms. Cheatham if Ms. Cheatham has seen that order. I did retrieve that from my colleague as well to make sure. So I don't know what Ms. Cheatham has seen and what, because I hear her still talking about the supervised visitation in that aspect, and we've heard the majority of the testimony in regards to history, in regards to that, to determine whether or not mother had completed what needed to be completed in regards to moving towards unsupervised visitations. But I believe the best way that Ms. Cheatham can have that is, I guess, the video.
And I think if we review the video, because I was in consultation with Ms. regularly until about 8:30 last night. I have reviewed the file extensively. The court file, my file, Ms. Hubbell's file, Ms. Regularly's file, not as to, just notes and things, but actual findings. And I see where they're, these petitions that are filed under oath where they say there was an admission, that the visitation supervisor was on the phone discussing other cases. I've got the dates from where the therapeutic supervision was taking place. I spoke with Ms. Regularly last night. She said it was unequivocal that Ms. Mullins was to be here. Like I said, Rule 45 says that subpoenas are continuing in nature in addition to being instructed to be here. She is absolutely critical of what happened and who told who what.
I'll let y'all talk for a minute.
Okay,
And then if
all right,
you
I
all
appreciate it.
could call Ms. Mullins and see where she is.
She's kind of gone missing, I think, but you can't really blame her, but still, you're under a subpoena,
Okay, I don't know if she still works at Camelot. Do we know if she still works at Camelot?
I don't know, they subpoenaed her, and I think they should have had the duty to reach out to the
We did,
witness.
and Ms. Regularly has made effort, my client's made efforts, and I just came in a couple days
I
ago,
understand.
and I was told that there was no equivocation about her presence being required here.
I do not recall that. I'm glad Ms. Mack has refreshed our memory on that. But if we can at least try and give her a call and see where she is, and we'll go from there. And I will take about a 10-minute recess, and that gives y'all enough time to,
Thank you, Your Honor.
Mr. Frakes, you need to say something, are you good?
I'm just raising your
You're just raising, getting ready for me to jump
in
off.
anticipation.
All right, let's take a 10.
Was in recess for 10 minutes.